Good evening. This is John Flannery, and I normally do a walk and talk, but this evening I'm going to do a sit and talk. And one of the reasons is because I think the issue is both complex enough and historical enough that I'm going to need some notes because I think it's important that I get right specifically what words have been said. I'm talking about the historic decision of the United States Supreme Court today, given to a man, a single man, absolute power in a nation that, since its founding, was defined by its democracy, and that is that we were all equal before the law. But the Supreme Court today has said, forget that. That's not who we are. That's not what we are. This Supreme Court has proved itself elusive of justice and fairness and fair play and a decent textual reading and historic understanding of the laws in not one but several cases, the most important of which is the decision today involving the immunity of a former president and the immunity of a president. I'd like to start with the remarks that I listened to, as many of you may have, of the President of the United States reacting to the decision today. The statement was about 5 minutes. It was at the White House. As far as I know, he took no questions afterwards. I will give you my summary. Some of it is verbatim of what he said. Other of it is what I caught. I haven't replayed the video, and you may hear it yourself. The President of the United States started with the following statements. There are virtually no limits on what a president may do after the decision today. Not even constrained by the Supreme Court's decisions. The court has already recently gutted voting rights and the right of a woman to choose and to have dominion over her own body. We have a former president who, when president, sent a violent mob to the Capitol and watched it on TV doing nothing. We are all aware of the gallows that were put up, purportedly to be used against the vice president who would not do what Trump wanted him to do because it wasn't the law and it wasn't constitutional. Gallows were erected. It was one of the darkest days in our history. We deserve to have an answer before the election in our courts of law charging various crimes against Trump. But it remains quite risky whether or not that will happen. Because of the Supreme Court, it is highly unlikely. America will have to render judgment itself. And Biden recommended that judgment be that Trump was unfit for public office, that he favors violence, and that this decision will embolden Trump, not constrain him. Our first president believed power was limited and belonged to the people. That's what George Washington believed, and he adhered to it, to the surprise of many, including those who supported him. But he remembered what the kings of England, what George III had meant to America, and to those who came here, fleeing that kind of government to establish their own. The law will no longer do it, that is, to make us all equal before the law. Biden said he agreed with Justice Sotomayor. She wrote a dissenting opinion. She was one of 3 judges who dissented. She said, by this decision, we have a king above the law. I dissent. That's what she said. Now, that's basically what the president had to say. Now, I'd like to talk a little bit about the coverage. And it's troubled me because we have so many people explaining and reassuring us it will be okay. Images from past messages such as this from dictators run through my mind as I think about it. But they had on ABC Sarah Isgur, I-S-G-U-R. She was formerly with the Trump Department of Justice, and she was talking on ABC. And she reassures us it's not as bad as Biden says. Well, and she says that's true because the prosecution can come into court before Judge Chutkan, who has the case in Washington, D.C., and perhaps still get it admitted, although she didn't go that far. Perhaps she should read the 119 pages of the opinion, as I and others have today. It is an experience at a loss of the promise of America, at least at great risk, if this election goes to Trump. I've said it, others have said it. This is the most dangerous election in my lifetime. It's the most dangerous election in the history of the United States. Long before this decision was announced, I said that the 6 Trump disciples on the Supreme Court would do what they were appointed to do, including, but especially, to make Trump a king, able to do what he wants, however lawless or violent it would be for anyone else to do it. This is a beachhead in Trump's efforts to replace our democracy with a monarchy, a form of government, as Biden said, was rejected by George Washington. Consider our structural plan of government in America, because it's collapsing. People may think they see the buildings and they see the people and they think all these things are going just fine, but they're not. We're in real trouble. Our 3 departments are the judicial, the executive, and the legislative. One of our 3 departments, the judiciary, is lost to what is just and fair and equal for they who appear before the court as equals. The executive branch is under fire, and when it was under Trump's control, it hinted at what Trump would hope to do if elected again. The legislative branch, the third, is known for its dynamic staticism. That is, doing nothing. Paralyzed, because no one will lead, no one will risk saying something, no one will risk objecting to the misconduct of Trump and others. Thus we have a governmental structure collapsing. I heard some commentators say, it sounds a little hyperbolic. Now, you or I would say exaggerated, right? We wouldn't say hyperbolic. So do you say hyperbolic to conceal the fact that you're admitting to exaggeration when a decision like this comes down that couldn't possibly be hyperbolic or exaggerated, when it is taking the entire history of our country and saying it doesn't matter? So, what did they do in the opinion? There is language in the opinion of the court that a lazy mind might find persuasive. But the language of the decision and the process set forth in the decision were to create, 1, a cover story for its power grab for Trump and for its prosecutorial interference with those who would resist such efforts and try Trump for the crimes he did commit in and out of office. The second objective in this decision is to direct the trial court, Judge Chutkan, to consider a score of charges that fit the limitations of the Supreme Court decision, perhaps ensuring a couple of things: that if those hearings are held, portions of the prosecution will go away like a morning mist, or it will simply delay the case until after the scheduled election in November. Now, what are the bones of the argument that they would have persuade us? Now, keep in mind that I use this language and I think in this language, but here's the thing: it can be manipulated, and is. So, the court divides immunity into really 2 frames, and I'm going to give you their definition in the opinion. Absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. Okay, did you understand that? Do you know what they were talking about? You weren't meant to. You were meant to think, oh, I don't know. When I was a less responsible person, assuming I am responsible now, in college, sometimes I would make up a word in a conversation that wasn't that interesting to me and use it as if it was a real word. I just make it up, you know. Phlogiston, which actually is a term that's in physics. But I'd say, I think we don't have enough phlogiston on the campus. And I just talk about it, and I would just act like everybody knew what I was talking about, and they didn't. That's what the Supreme Court's doing here. They're talking about the president's conclusive and preclusive constitutional authority. Now, here's the other error that people make with Trump. When he says something, everybody runs around and uses his language, and in this case, the court hopes that we'll use their language. So, in other words, where Trump has the greatest power, that is absolute immunity, his misconduct is most isolated, insulated, and protected from inquiry, prosecution, or anything else like that. Now, the second frame of immunity is he is entitled to at least presumptive immunity from prosecution for all his official acts. Oh yeah. We are not entitled to consider the president's intent when considering an official act that he performs. So, and they give some examples, but let's talk a little bit about what's going on here. I don't know if you're familiar with a game of the streets called Three Card Monte, which is a scam. It's a wagering thing. They're on a street corner, and they put out 3 cards, and you have to guess certain things. And there's always a shill in the crowd who does it and wins, sort of egging on the innocent to try it, and that person loses and loses the amount of money. So, what the Supreme Court is doing malevolently is asking us under which category may we hold the president responsible. And if you look at the opinion, not really. You don't get to hold the president responsible. It's like the old shell game, peas rather than cards and stuff like that. But we're not losing a 20 spot on this game of chance. We're risking our freedom on a court opinion that betrays our republic, nothing less. Can we be more specific? The court said that Trump's conversation with the acting attorney general, that's when they were going to be helpful in what was going on in Georgia. That's a problem. That's an example of a problem. See how they go. It's not enough to say this general principle. They want to say it in such a way that they're letting us know what they're trying to screw with. So his interaction with the vice president, that's off limits. His interaction with state officials, oh no. Could that be the Georgia officials? How do you get by that one? It could be certain private parties. And, oh yes, his comments to the general public, like, oh, hang on for tomorrow. Who knows what's going to happen? Now, so that's a short look at a long opinion. I suggest you read it if you're patient. It's not as much fun as James Joyce. And it's not as harmless as James Joyce, unless you have a bad night's sleep after reading his 41-page run-on sentence. Ask me about it later. So I go to the concurring opinion of Thomas. And what does he say? Now, first of all, he shouldn't even be saying anything, and Alito shouldn't be saying anything either. These two are conflicted out. But the first sentence of his concurring opinion is, few things would threaten our constitutional order more than criminally prosecuting a former president for his official acts. Are we prosecuting for his official acts, or are we prosecuting for pretending they're official acts when they're criminal and that he can be prosecuted and indicted for them? So it's not the eye of the beholder, it's the power of the writer to change the law, but they don't have an army or anything to enforce this. And that's one of the questions that come up when you change the law in such a way that the public says it's not fair or just. Now let's go to Sotomayor. She leads the 3 dissenters. Because She said, because our Constitution does not shield a former president for answering for criminal and treasonous acts. Now, what does she say about the majority's analysis? Now, you've heard my remarks, and she goes into it in detail. And it's a good exercise if you want to see what we can expect as they try to take our freedom away with the monarchy that they would put in place starting out with Trump, and who presumably will pass it on to his dumb children. Or maybe the smarter women in the family, I don't know. But she said the majority invents, which is, I was suggesting because I knew what she said and what I believe myself because I could read it. But as an associate justice who spends much more time on these issues than I do, she said the majority invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. Think about it. We have 3 members of the court that say this entire decision is bogus. And the commentators are not reacting to the actual opinion. They say they understand, they can't believe, they don't know. And I'm sorry to be like this, that is criticizing others who are trying to be helpful. But they're not being helpful because they believe so strongly that the court could not be an organ that would do this. They then search for explanations that are not criminal, not corrupt, to explain what's going on. Now, those of you who read the Constitution probably read Article 1, Section 3. Now, I spent a lot of time with this section myself on the Hill because I worked on the impeachment with a lot of other people. In fact, Abby Lowell was our counsel, our chief counsel, and I was a special counsel, and we all had our assignments. And we worked on the impeachment. And because of the impeachment, we considered all those sections, and there were great materials we had in testimony and so forth. So Article 1, Section 3 says that impeachment is for removal, but does not affect that the president, quote, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. How do you get around that language in the Constitution? How do you? You invent, and that's what Sotomayor was talking about, you invent these atextual, ahistorical, and unjustifiable immunities. So we create the kind of story that our children would watch on a Saturday that has no basis in history, experience, can't be found in the Constitution, but has one point, and that is the theory going back to the Federalists, to Hamilton, believing that he was a monarch. John Adams argued how he should be called His Excellency when he sat as vice president in the Senate, as its president by the designation of the Constitution, given that he was the vice president of the United States. But Washington, he left. Washington didn't think of himself that way, was uncomfortable with that. And think about it, all the awards and kind words and historic things he accomplished, and the man still remained faithful to whom he was. And some have read his short list of things that you should do if you want to be a great man. He was a great man, and especially on this point. So, you might say, well, if you're impeached, how can you be prosecuted? And the answer is, that's what happened to Vice President Spiro. He was not impeached, and so he said the section that I just read to you could not be used to prosecute him because he has to be impeached first. And the court, as to a vice president, said, no, that's not the case. There's 2 different acts. You can be indicted. And he was indicted while he was being investigated and indicted while he was the vice president. He was in office, okay? Now, it's not always easy to find things in documents, but I specifically searched the 119 pages with a control find method, because these are PDFs, to make sure that I could find whether or not there was a reference to this section, Article 1, Section 3. And Sotomayor, at page 6 of her decision, quotes this very section for the purpose that I say. Now, the majority quotes this to answer her, in my opinion, because they exchange drafts when they write these final decisions. You go to page 32 of the majority opinion, and you'll find a different construction of this. Like, oh, it doesn't matter, you don't do anything, which is what you can do when you're in the majority. I got 6-3. Okay, so you don't like what we say? That's the way it is. So Sotomayor said the court makes Trump a king. So what do we do about this? Well, we could moan and whine, as some have. I think what the president did was very responsible, setting the mark for what is the implication of what's happened, and I presume there'll be additional questions coming down the pike. What would I recommend if somebody would give me the chance to effect a remedy here? First of all, what's the government going to do? This is what the government should do. Judge Chutkan should bring the parties into the court as per the Supreme Court analysis and ask for a presentation starting Monday to next Wednesday on what may be admitted, what the special counsel may withdraw, and to give evidence in writing as one might in motions before trial normally. They call them motions in limine, and judge all those things. Now some say, well, then those decisions would be appealed. No, not normally. They would not be. They would not be appealed. And no one should give it away, because it wouldn't happen for you or I if we were in this situation. It won't happen for anybody else. And then set the trial down for August the 1st. Now, if I were president, and I don't want the job, but if I were president, I'd say, well, okay, the Supreme Court said what I say is true. Official act. I direct you, Judge Chutkan, to analyze the data and start this trial by August the 15th. Go to it. And I demand that you sit and finish it by the end of September, mid-October at the latest. Thank you very much. That's what we do, number one. What else do we do? I direct my Attorney General to move to recuse Judge Luce Cannon in Florida. Two can play this game. You just said, I have unlimited power. I'm going to use it. And that's how I'm going to use it. Because I can tell the Attorney General what to do, because you said the Department of Justice, so-called, that's an official act. So that's what I'm going to do. I'm going to do those two things. Now, what do? What we do is we go out and kick ass. We write about this. We talk about this. We contribute if we can. We vote. We run for a local office. We could have legitimate electors, you know. A good friend of mine, that was one of his proudest moments when he was an elector for, I think it was Obama. I'm pretty sure it was Obama. This is in Virginia. So, and what are the stakes? The stakes are what they were from the beginning. Remember, if you had a class in which they taught it, and they don't, that the Constitution was written behind closed doors. I believe it was a number of days. But there was a strict rule that the deliberations and the notes, I believe it was Madison or Mason, would not be revealed for 40 years. And if it hadn't been for Patrick Henry and others, there wouldn't be a Bill of Rights. And who knows, there might not have been amendments to the Constitution. So that's what matters. And when they came out of these closed proceedings, and a person asked Benjamin Franklin, so do we have a republic or a monarchy? He said, a republic, if you can keep it. This is one of the most trying moments in my lifetime for us to preserve and protect a government that represents all of us, with no man or woman above the law, with equal justice for all, with recognizing freedoms. A freedom is not something the majority gives you. A freedom is something that you have as an individual right that you can assert against everyone else. And that's the significance. of killing, for example, Roe v. Wade. That was an individual right no one could take away from you. And they changed it into whatever a state might want to do. And they create a statutory provision that they can change, and it's not a right for all time, and it's a right based on the majority deciding what right you may have if you're a woman who's pregnant, or your daughter is, or your sister, or whatever. This is a sad time in America, but it's not a time to lick our wounds. There are a lot of people whining. Some are going to continue to say they want to kick Biden out. I want him to live until he's sworn in. I'd like him to live the next 4 years as well. But in my opinion, this entire election is about you're for or against Trump. You're not for or against Biden, although there's plenty of good reason to be for him, and there are concerns that we legitimately have. So I encourage you to think in this fashion. You're not bound to it because, unlike Trump, I don't have absolute power. So tomorrow I'll probably be out walking. I was also tied up today because we are fighting to get bail for a client, and I'll be in court tomorrow morning at 9 a.m. So thanks for listening. Look forward to talking to you again soon. Bye-bye.